Any mention?
Lordship, I beg to mention item number 21.
20?
21, Lordship.
I don't do it. 21.
Already informed all the concerned
1
parties.
second. You are for the other side?
No, Lordship.
Who's the 21?
Lordship, I'm for the petitioner, Lordship. Lordship, this
You are for the
matter,
petitioner 21?
21.
Okay, yes.
Lordship, we have already filed a rejoinder.
We asking for how long?
2 weeks time, Your Lordship.
2 weeks. No objection?
No objection, Lordship.
Obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item number 16, Lordship. I pray this let the matter may come after 2 weeks. I have some personal difficulties, my lord. Some personal difficulties.
Personal difficulty?
Lordship.
1 week, okay.
Lordship.
Yes.
Most blessed, Lordship.
May you please, Your Lordship, I beg to mention item 18.
18.
Lordship, ongoing settlement is going
What's
on.
going on? Who's
We are
other
yet to
side?
receive the latest instruction. State respondent.
For the
Is it
state,
correct?
Your Lordship, we've taken instructions from the department. The department is not aware of any settlement.
What's the,
the
which
moment.
post is this?
Lordship, we are yet to receive instruction. It was the state respondent that informed this court that.
No, you take instructions after 1 week, yes.
Highly obliged.
Obliged, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 20, Your Lordship. I pray that the matter may come up after 2 weeks, Your Lordship.
What's the matter about?
It's about the outcome matter, Your Lordship.
Why 2 weeks? Is
The conducting counsel is on sanction leave, Your Lordship.
for 2 weeks he's on sanction leave?
No, Your Lordship.
Then 2 weeks, okay, yes.
Highly obliged, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention item number 22, Your Lordship. This matter will come after 2 weeks, Your Lordship.
Who's the other side?
Your Lordship, Ms. Koni is in this matter. Your
I'll
Lordship, for the corporation, she's on legs in court number 1.
I'll inform her, Your Lordship.
Inform her before mentioning.
Okay, Your Lordship. Much obliged, Lordship.
Call out.
May it please Your Lordship. Lordship, I beg to make a mention of item number 17, Your Lordship. I pray if this matter may be listed off.
Come back.
He's on sanction leave, Your Lordship. Similar prayer for item number 19, Your Lordship.
Yes. Like 1 week, 1 week. Yes.
Highly obliged, Your Lordship.
Call out.
From supplementary list, item number 1.
Yes.
May it please Your Lordship, the petitioner herein is aggrieved with the non-payment of her salary, since September
He's working
2022.
sanction post.
Yes, Your Lordship.
Approved.
Yes, Your
Very
Lordship.
approved.
It was approved by the government in
Yes. When is your
29/7/2022. It was approved by the government.
Why has that been paid? What's the reason given by the respondents?
They have not replied to our representation letter, Your Lordship. She was appointed on 6/7/2022. 6/7/2022. She was appointed, and the government approved on 29/7/2022.
You're there?
Hello, time for 1 and 2.
Yes.
Number 3 is the secretary's term and the
That comes with the petitioner. MS Langi.
Yes, Your Lordship.
Yes. Issue notice. Mr. Kim Varsaji. Regi except we have 1 and 2. No further notice called for. Notice to issue to the 1 or 3 within 3 days. This after 3 weeks, yes.
Highly obliged.
All instructions affidavit.
Item number 2.
Yes, Mr. Zarika.
Please, Your Lordship, that is the matter regarding the Gamburas, my lord, bifurcation of the villages without any
Bifurcation of the
village, my lord.
without what?
Without giving any opportunity of the hearing, without inquiry, all other things, my lord. Then I am coming to my appointment, my lord. Page number 22, my lord.
Number, page?
Page 22, my lord.
Page 22, okay. Yes. So, Borshi Banda
Yes, my
and
lord.
Gola Digil.
Yes, my lord.
Gola Digli.
Yes, Goladigli part 2, my lord.
Okay, what happened then after
Now,
that?
here, my lord, what happened when they are appointing me as a Gambura? There is a inquiry, a spot inquiry, Mojida report, and the views of the publics, and no objection given by the headman, Gamburas of the Bolarvita. Then only they have appointed me as a Gambura on 23rd March 2016, my lord.
Okay.
Then I am continuing as a Gambura of the village.
This Borshi Banda and this Gola Digli.
Goladigli part 2, same. Only
Yes,
few
same
villages.
village.
That is the
Where two
contiguous
names?
village. Contiguous village, my lord. They are having only
Judgment for two villages.
only 20 or 25 families are there, my lord. Before it was the part of the Bolarvita, my lord. Then what happened when the public came to know that there is some complaint? So they have filing a representation dated 28 August 2023, requesting that not to take into consideration for bifurcation of this thing. Even the petitioner also filed a representation on 19 December 2023, my
So
lord.
you agree with 24 April 2024?
Yes, my lord.
Yes, the Jal Commission concerns agreed.
Yes, my lord.
Create a Gambura area of Godalgili.
Part 2.
Right.
Then impugn order, my lord.
Yes.
The page number 26, my lord.
Yes.
That is notification, my lord.
Right. Yes, Mr. Dey.
Okay.
Before my learned senior start, my lord, I am the caveator here, my lord.
Wait, as a caveat, take out a caveat. Blame my caveat.
My lord,
You filed it just now.
no, my lord, on 31st, my lord.
Yes.
But unfortunately, my
What is your objection?
My lord, our objection is there is a problem with regard to the issuing of certificates and smooth functioning of the Gambura-ship, my lord, which is why we made a representation to the GHADC, and GHADC, in pursuance to the prayer, GHADC issued an order for spot inquiry, my lord, to the entire issue. Then after the spot inquiry, the inquiry report was submitted to the GHADC. Then GHADC issued notice to both the parties, my lord. After hearing both the parties,
About the bifurcation?
Yes, my lord.
But he says that he has no notice to him.
No, my lord. They have not served.
If my lord allows us some time, we will bring on record to the order, my lord.
About the maintainability, my lord. About the maintainability of the petition. Now, my lord may kindly see, in pursuance to the notification dated so and so, the impugn order, my lord. If my lord may kindly come to page 26.
Yes.
My lord, now, first, let us go to the appointment of the petitioner, my lord. The appointment is for two villages, my lord.
Yes.
Now, we feel that there was required for bifurcation, for the proper
Whatever it
administration.
is, but
my
then
lord.
even he is appointed for two villages without causing him, you
No,
can't
no,
take
my lord.
away
No, that is
one
not
part
correct.
of his-
That is not correct, my lord.
Yes.
That is not correct. Moreover, my lord, now by bifurcating that, my lord, two villages, two different Gaburas, we have set up two different Gaburas. That is a policy-making decision of the district council, my lord. First thing, my lord. Second thing, my lord, may kindly see page 26. In pursuance to the notification dated so and so, the executive committee is pleased to appoint so and so.
Yes.
As a Gabura of so and so, bifurcating so and so for 6 months with effect from this date to this date, my lord. Now, my lord, this notification is not under challenge. In pursuance to this notification, my lord, we are bifurcated.
He's annexed it. You know, challenge this notification, Annexure 5.
Yes, I have challenged both.
Where?
In the prayer.
In prayer. See a prayer?
Yes, yes.
No.
Shall I come, my lord?
No.
Yes. Shall I read out, my lord? Page number 7.
It's there, my lord.
Okay, right. Yes,
correct, my lord.
you will take a caveat petition 53 2024. Stop. This is a caveat filed by caveator Shri Mahabul Sheikh. Stop. Represented by Mr. S.K. Hassan. The caveat accordingly stands discharged. Then in the main case, heard Mr. H. Hazarikala, considered petitioner, issue notice. Mr. SD is present, accept notice on behalf of respondents 1 to 4 and SK Hassan on behalf of the caveator. Respondent number 5. Such no further notice called for. Stop.
Copy maybe.
Yes, copies of the petition be made over to the respondent number 5. Stop. As a party represented and there's a prayer for interim orders, this is matter for 1 week consideration interim orders.
My lord, up to next date, my lord, interim order, because as per the Gamburas, this thing, my lord, land law.
If you have concealed information,
no, we have not concealed, my lord.
If you have concealed, if you haven't concealed, then you might be open for interim orders. Yes.
I'll produce the record 1 week on the next day. We'll
Yes, what is entirely up to you. Respondents need to produce records indicating the manner in which the village is bifurcated on the next day.
As there is no rule, my lord, for bifurcation.
No, that you argue on next day. Yes.
Item number 3.
This is.
Who was representing in the other case, Stevenson Lalu?
Mr. Paul Sinkon.
Mr.
Sinkon.
Which Mr. Sinkon? N. Sinkon.
Nilotpal Sinkon.
That matters in fractures then?
Yes, Lord. But I'm challenging the order dismissing the election petition and default, my lord.
Where's the order?
But before that, let me just take your lordships to the previous orders, my lord.
Yes, where's your senior?
Your lordship, there's a bereavement in the family, lordship. He cannot be here today.
You take notice at least?
Yes, your lordship, we take notice.
Yes, heard Mr. Philip Nongzi, the council petitioner, issue notice. MSc Namkhala Vice, Mr. Vijay Kanta is present behalf of respondent with 1, 2, and 3. No further notice in respect of these respondents. Petitioner will take steps for serve notice on the remaining respondents within 3 days. Just after 2 weeks.
2 weeks.
Right, your lordship.
Item number 4.
Yes. Yes.
Lordship, the instant writ petition is filed to challenge the inquiry report, which was submitted by way of inquiry report.
Inquiry report by whom?
By respondent number 6 in WPC 90109 of 2023.
By respondent number 6 in WPC number
109 of
109. Which this is?
102. Yes, Your Honor.
Yes.
Your Honor, the said writ petition was dismissed by order dated 2/5/2024 as frivolous and upholding the inquiry report, which was never challenged in that writ petition 109 of 2023.
Where is that order?
Your Honor, the order is in Annexure 8, Your Honor.
Page.
Page 241, Your Honor.
241?
241, Lordship.
Same petitioner there?
Yes, Lordship.
Where's the operative part?
Page 247, Lordship.
So in the earlier petition, you prayed for the inquiry to be conducted.
Lordship, we pray inquiry to be conducted against the respondent number 6 for releasing the fund during the pendency of the complaint. Whereas your Lordship has passed the order regarding the inquiry report. We have never challenged the inquiry report.
Inquiry report? It's paragraph 6.
Your Honor, we challenged the inquiry report in division bench, Lordship, where the judgment dated order 15/2024 is passed in
Yes.
That is page number 248, Lordship.
Yes. According to even though sales outside extracting the inquiry, that is not warranted. As long as it requires. Were you representing an inquiry? before the whoever conducted inquiry or respondent, were you represented?
Your Honor, the inquiry was not conducted. The inquiry report was given to us when the writ petition 109 was filed in the month of November. When the complaint was given, we have not received any inquiry report.
This inquiry report dated when? Very challenging now.
11/5/2023.
But at the time, 11/5/23 is the subsistence of the writ petition.
Yes, Lordship.
Then you see, as noted earlier, the praise for direction for conducting an inquiry and also to question the respondent number 6 as the release of funds at VEC. Is further noted the entire petition is based on a perceived complaint with regard to improper execution of works by said VEC and the present skepticism of respondent 78. From where is placed in the pursuant of complaint, a report dated 11/5. So you made a complaint, correct?
Lordship, yes, we made a complaint.
Then on your complaint, an inquiry was conducted.
Lordship, we have in the complaint which we have filed to the BDO, respondent number 6.
You never took part in inquiry.
Lordship, we have never took part in the inquiry. No statement.
So then what do you mean no statement?
Lordship, the major component of this VSC for the inquiry, the respondent have to issue notice.
Okay, yes.
For the particular date.
So even division bench, what does division bench say?
Your Honor, to modify the order of the single judge, and they have given the liberty to file the.
All parties bearing
Page 250, Lordship, para 7.
Okay. Yes. Yes, anything to say?
My lord, I will require instruction in this case.
Yes, heard MS M.
Plow.
M. Plow for the petitioner. Issue notice, Mr. Ensign accept notice on behalf of respondent 125. Notice to issue response number 78 and 9 within 3 days. Yes. This after 3 weeks.
From the main list, item number 1.
Yes.
Lord, this is a revision against the order passed by the learned court below, my lord, the additional judge, this is the council court, my lord. This matter pertains to the
matter is for what? For
admission hearing, my lord.
Okay.
My lord, what had happened is that the respondent herein had filed a probate case, my lord, before the trial court below, who was then sole respondent. My lord. The probate case was filed, which was registered as Miss Case number 1 of 2018, my lord. After that, notice was issued to us. We are 7 of us, my lord. So we file a show cause. After filing a show cause, then, my lord, issues was framed based on the show cause filed by us.
Yes.
In as much as around 13 issues were framed, my lord, by the lower court.
Yes.
After the issues were framed, my lord, we had filed a petition for preliminary hearing on issue number 1, 2, 7, 8, 9 and 11, my lord.
What issues are those?
Issues, my lord, if your lordship kindly come to page 7, my lord, para 6. We have challenged the maintainability of the probate case, my lord.
Which issues you challenged?
1, 2, 3.
1, 3.
1, 2, 7, 8, 9 and 11.
3, 7, 8, 9.
These are the 6 issues, my lord, which has been challenged by us, my lord.
Okay.
On the basis of this, my lord, they have filed the show cause, and after hearing the parties by way of written argument, my lord, the learned trial court, by the impugn order dated 24/7/2023, has rejected our challenge with regard to the maintainability of the plea. What will that your lordship impugn order will find at annexure 11, page 240.
Will you say that it's still lying there for the
my lord,
before the probate court?
Yes. That has been kept by bench in by virtue of this CRP, my lord. The entire proceedings.
But there's no interim orders.
No interim.
No, my lord. We have filed an application because the challenge is purely a question of law, my lord.
Where is the order?
My lord, will annexure 11, page 247.
My Lord, I've quoted it in the page 8, my Lord, if you paragraph 7.
Your memo.
My Lord. Paragraph 7. Paragraph 7, order. On having perused the written submission of the alert counsel for both parties and upon proper perusal of the instant application, its show cause along with the material available on record, it is found that the objector have challenged the maintainability of the will dated so and so in respect of the landed property mentioned in the said will, as the objector are contended that the suit properties has already been sold by the deceased mother of the petitioner, white sale date so and so and so. The objector has are also contended that the will alleged to be executed by late so and so is false and manufactured, and late so and so is an illiterate woman who cannot read or write. It is further contended that the deceased testatrix has appointed an executor to the will dated so and so, namely so and so, who would execute the will, and the petitioner, being only a beneficiary of the will, has no right to file the instant petition, that is the probate matter. On having perused the application for hearing on issue number so and so and so, it is found that issues sought for hearing involve issues of fact. Under the provision of orders so and so so and so, provides that whereas issues both of law and of facts arises in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of an issue of law only, it may try the issue related to A, the jurisdiction of the court, a bar to the suit by any law for the time being in force, and for that purpose may, it thinks fit, postpone the settlement of other issues until after that issue had been determined, and may be dealt with the suit in accordance with the decision of that issue. Based on the above provision of law, I am hereby convinced that issue prayed for by the objectors does not involve issue of law, which requires to be disposed of at the preliminary hearing. However, the issue that has been prayed for at the preliminary hearing requires to be determined through evidence. Furthermore, as the question raised by the objectors that the petitioner, being the only beneficiary of the will, has no right to apply for probate, in this issue I am of the opinion that in the purported will dated so and so, the testatrix has expressly named the petitioner in the said will. Hence, the petitioner and the said Archangelo Sindor may be admitted to apply for probate. Based on the above finding and observation, I am hereby convinced that the preliminary issue number so and so so and so shall have to be decided through evidence, my lord. My lord, why is this challenge, my lord? If your lordship kindly take the Succession Act, my lord, section 222, my lord. What does the Act say, my lord? Our entire case is based on the section 222.
Are you saying that because executor has been named in the will, he only one can seek probate?
My lord, that's what the law says, my lord. 222, my lord. Section 222, my lord.
Where's the probate application? Is it next year?
Yes, my lord. The application, my lord.
Now you stand also that this property has already been alienated before.
Yes, my lord. It has been bought by the respondent, my lord.
By which
respondent? By the daughter.
By you?
We are 7 of us, my lord. We are siblings, actually. By respondent number 7, my lord. Annexure 1, my lord, is the petition, my lord, application. Page 19.
Yes.
Annexure 1 is the probate application, my lord. Page 19. In the will itself, my lord, the executor has been expressly named by the testatrix, my lord.
It's filed since 2018.
Well,
it's been stuck since that time.
Well, then issues after that, my lord, the only 23 the hearing was concluded with regard to the maintainability, my lord.
Yes. Okay.
So, my lord, our contention is that as in the will dated 1/9/2017, the
where's the will?
The will is at page.
Are you challenging it as a contrived will? That's contrived is manufactured.
My lord, that is one aspect.
If that is one part, then it has to go for evidence.
That's one part of it, my lord. That's one part of it, my lord. We have challenged even in the show cause itself. We have challenged the maintainability.
But now, if you challenge it, you see it is a fake will.
My lord.
And at the same time, you say the executor is named in the will, correct?
Yes, my lord.
Then how could those submissions both? They can't go together. Yes, let's see the will.
My lord. Annexure 2, my lord. Page 75. Translated copy, my lord, is at page 81. If I may read, my lord. This is my last will and testament, and I hereby revoke all previous existing will, and I further affirm that this is my last will and testament, and that the same shall come into force after my death. As it stands, I am the absolute owner of 2 plots of land situated at Umrok, Maukasiang, Shillong, and both are situated adjacent to football ground, whereby one plot I had acquired by outright sale from so-and-so, about measuring about so-and-so, more or less, and the other plot which I have acquired by way of gift from so-and-so, measuring about so-and-so, schedule, my lord, have been mentioned.
Now, one thing reading the will, now you see the properties are already alienated.
My lord.
Prior to the execution of the will.
Prior to the will, execution of the will, my lord.
Then, Mr. It's not a question of will executed and properties alienated by the testator subsequently, no.
No, my lord. Will has been executed subsequently.
Will subsequent to the alienation.
Yes, my lord.
That puts the case in a different
No,
dimension
but my lord,
together.
that is the other aspect of it. The main challenge which is under before your lordship is that as there is an executor which has been named in the will, my lord.
But at the same time, has an issue been framed that this will is a fabricated will?
Yes, has been
Yes,
framed.
issue has been framed also.
Yes, yes.
Then they'll all go together.
But my lord,
Because then on one hand, yes, 222 says that only to
Yes,
name executor. But then by implication also, does not the petitioner come in to be?
No, my lord. If it's a specific, I have a decision on that, my lord. If it has been expressly, the executor has been named, it is the only executor who can.
I'll see.
Very old decision, my lord. This is.
In all probable matters, you won't find new decisions.
My lord, 1917, my lord.
17?
Yes.
Yes.
1917 is there.
You won't find new decisions.
One is 1917, my lord. Relevant paragraph is 3, 4, and 5, my lord.
Patna High Court.
Patna High Court, my lord. Relevant paragraph number 3, 4, and 5.
Where's the executor now? Don't know where he is.
They will be. They should be.
Yes,
she is the beneficiary, my lord. The one more decision is there, my lord.
My lord,
2018.
actually, the question of executor, the learned trial code in the issue number 11 has framed the issue as to whether the testator at the time of execution of a will has named Mr. So-and-so as the executor. And that question is yet to be determined by way of evidence, Your Honor.
My lord, that has been expressed in the will itself, my lord.
Your Honor, if you peruse at the...
Let's see the issues where it's been framed. Where's the entire issue? All the 13 issues.
The issues is in Annexure 8, my lord.
Annexure 8, page 234.
234.
234.
Yes.
And the relevant issues, Your Honor, is at page
Let's see all the issues. Yes,
239.
234. 1 second.
Page 235 is the issues, my lord.
Now, whether instant case is whether issue number 11.
11.
I think we'll admit for hearing. Admission hearing, I think, will not be possible to.
You know, my lord, because regarding the landed properties.
No, we'll admit for full hearing. That's what it's only because we put admission hearing thing is only one short point, but it's more to that because other issues reflect that. Yes. Heard Mr. L. Kriyam, legal counsel for the petitioner, and Mr. Sinkan for the sole respondent. After hearing the legal counsel of the parties, the matter stands admitted for hearing. List after 3 weeks, records of the trial court to be called.
Probate miss case number 1 of 2018.
Probate case.
Obligation.
Item number 2.
Try to finish up the first hearing on.
May it please your Lordship. Lordship, we have already filed affidavit in this matter for item 2 and 3, Lordship.
Your Lordship, I'll be filing my rejoinder to the state's respondent.
Course of the day.
Yes, Your Lordship.
The course of the day.
Yes, Your Lordship.
Mr. Passenger submits that the rejoinder will file the course of the day.
For the respondent.
Just after 2 weeks for hearing.
For the respondent number 5, I'm yet to file, Your Lordship.
5? Who's 5?
Lordship, I'm for
My lord, they were the newly impleted party, MORTH, my lord. They were subsequently make a party.
They have already filed the affidavit also.
My lord, we are waiting for the affidavit.
No, 1 second. Who filed affidavit? You are for 5.
Yes, Lordship.
Then say that the Thomni MS A Pradhan submits that affidavit on behalf of 1 of 5 has already been filed. You filing journal to that affidavit today?
For the state's respondent, Your Lordship, today.
Then you say that also. Mr. Papsantev submits that with regard to the affidavit filed by the state respondents 1 to 4, the rejoinder will be filed in the course of the day. As for the affidavit filed by 1 to 5, the praise allowed how much time?
2 weeks time, Your Lordship.
2 weeks time for rejoinder. Yes, thereafter.
1 to 3.
Okay, 1, 2, 3. 4th 4.
4 is
Lordship is yes, Lordship. We are for 4, Lordship.
Okay. Subject was correct.
Highly obliged.
Item number 4.
May it please your Lordship.
Well, yes.
Your Lordship, as per the last order, your Lordship has directed the petitioner to obtain instruction in pursuance to the order dated 24/4/24, your Lordship.
Yes, speak a bit louder, Mr. Yes.
Your Lordship, here the petitioner, they want to proceed with the case, your Lordship. So the petitioner want to proceed with the case.
He wants to?
Proceed with the case, your Lordship.
24/4 what?
Here, as per the order 24/4/2024, your Lordship, the state respondent has suggested the petitioner to address their representation.
To be disposed of?
No.
You don't want representation to be disposed of?
We want to proceed with the case, your Lordship.
Let them proceed then.
My lord.
Yes, are the pleadings complete?
No, your Lordship.
Pleadings, I'm not very sure the pleading.
Lordship, we are yet to file affidavit.
What about state respondents?
My lord, I believe we have also not filed our affidavit here.
Yes, MS S.
We have
Chalam
not filed, nobody.
on instruction submits that the petitioner, though the representation is pending, is desirous of proceeding with the matter before this court. As such, MS Arconi for respondent number?
My Lord, state respondents number 1 to 5, my Lord.
1 to 5, MS Ibrahim for?
6 to 10 and 13 to 15, Lordship.
6 to 10 and?
13 to 15.
What about the others, 11 and 12?
Service is completed, Your Lordship.
Pray for and allow 2 weeks time to file affidavits. Yes, list thereafter.
Highly obliged, my Lord.
Item number 5.
In this matter, I was verbally instructed that the order has been complied with. I am asking for the record, my Lord, so that at least we can
We have to
produce
take
it.
instructions, Your Lordship.
You got instructions?
No, Your Lordship.
Not complied with?
We haven't got any instructions.
Yes
Your
or no, you have not got?
No, Your Lordship.
It was for the demarcation of a land, my Lord.
Mr. SD submits the as per instructions. The order stated to be violated, dated
13/7/2023.
has been complied. MS PS4. How much time?
2 weeks, Your Lordship.
To obtain instructions.
I will also produce the record.
Yes, Mr. Day to produce the compliance report next day. Yes.
Item number 6.
Yes, yes. No. Please, Your Lordship. Lordship, we have taken step for the matter.
Your Lordship, I am appearing for the sole respondent. And we have reached. Lordship?
Name.
A. Nandi.
A. Nandi.
We may be allowed some time to file our affidavit in opposition.
This is a civil revision, no affidavit. Are the records necessary?
Pardon?
Are the records necessary?
My Lord, quite, my Lord. Not required.
Not required. Then we'll fix a date for hearing.
Yes, my Lord.
Or we can finish it off now. What is the matter about?
Your Lordship, can it be fixed on another day? If it will be helpful.
Okay, take a date.
Second
Mr.
week
D.
of
Nandi?
A. Nandi.
You're Mr. D. Nandi's son?
Yes.
Okay, Mr. D. Nandi. A. Nandi, sorry. Has entered appearance behalf of sole respondent today. As such, notice is complete. Stop.
Second week of July, if Lordship, it is possible.
Lordship, interim order is there. Kindly extend
Urgency is
interim.
there? Any interim orders there?
There's an interim order, my Lord. Kindly
In your
extend.
favor?
Yes, our favor, my Lord.
So you're quite happy with the interim order operating?
I need to take instructions, Your Lordship.
And then we list it up for 2 weeks.
My Lord, interim order may be continuing.
Yes, this is a matter of 2 weeks to enable the council to obtain council to respond up to instructions. Meanwhile, the interim order pass away should continue till the next day.
Hello.
Much obliged.
Item number 7.
Please, Lordship. This matter, we have filed the affidavit of service to the respondent number 4 and 5.
3 and 4.
3 and 4, yes, Lordship.
Who are 3 and 4?
3 and 4, they are executive member and the chairman of the municipal Bakmara, my lord.
Oh, the same Bakmaras?
Yes.
They always receive notice but never appear.
Lordship.
They always receive notice but never appear.
Yes, they have already received on the 27 March 2024.
Has been filed by the writ petitioner. Stop. An affidavit indicating service upon the respondents number 3 and 4 has been filed by the writ petitioner. Stop. Where is the item delivered?
This one is annexure. I have fixed annexure 1 to actually this one on 27 annexure 1 is indicated delivered on 27 March 2024.
No? Which shows that the respondents were served on 27/3/2024. As such, no further notice is called for. Yes, MS Shah, what do you want?
Your
You're
Honor,
not
for the
filing
state.
affidavit.
Your Honor, after the municipal board, maybe.
Yes, list this matter. after 2 weeks enable their appearance.
Lordship. Must place Lordship.
Item number 8.
Because Mr. Depp or Mr. Dale appear, I think, eventually from Bangmara Municipal Board.
They have taken the petition last time.
Lordship, in this matter for respondent 1 and 2, I'm praying for some more time to file the affidavit, Lordship. I'm yet to receive instructions.
3, who?
For respondent 1 and 2 district counts. This is where the 2 daughters can patta issue.
We said records have been received.
Yeah, records have been received, Lordship, but we want to file the affidavit. And
I will also require more time, my lord.
send the records without any instruction.
Yes, we just let him, Mr. S. Dev for respondents 1 and 2, and Mr. Pelaman Nobri for 3 and 4. Pray for not further 2 weeks' time to file affidavits. Interim orders passed, election will continue from the next date. Yes.
Item number 9.
Pray for some more time to file an affidavit.
Where's the petitioner?
Petitioner
Is the guy in Mansion House?
the mansion house, yes.
No, what happened to the case in Bombay?
It's still pending, my lord.
But he said that day was listed on that day itself.
Lordship,
The matter
I
has come up last.
no update as to any disposal, my lord. I'll take instructions.
Lordship, it is still pending, Lordship.
Still
It
pending.
was not taken up on that date.
Lordship, we have taken instructions. It was not taken up, Lordship, and now
It's not disposed of. That's the instruction that I have.
Yes. Are you filing affidavit?
Lordship, I'm praying for some time, Lordship. We have received the comments. So
Yes, MST Yangi AG with said Inong Country 1, 2, 3, and Mr. Chanda for R4. Pray for not for the 2 weeks' time.
3 weeks would be better, Your Lordship.
3 weeks.
3 weeks. And what else CNG brings?
Yes.
Item number 10.
Yes.
Let's see, 1 second. Lord, we'll require a little bit time to file our affidavit. 2 weeks, my lord.
Already 2 weeks granted last time.
Lordship. Because the matter is pending before the government for creation of a post in favor of the petitioner. That is taking a little bit of time. So we'll only place that before Lordships.
Yes. 2 weeks' time as prayed. Allowed to the responsible active. 2 weeks further time.
Obliged.
Item number 11.
Please, Lordship, here instructions were awaited from the. It's only for disposal of my representation.
Your Lordship, there was no representation. We did not receive any representation.
What is that, Mr. Dev?
Your Lordship, even if you check their next year's,
File a ghost representation.
They have countersealed
And Your
it.
Lordship, the petitioner's late husband, the deceased employee, already submitted his resignation in 1993. Tendered his resignation, accepted in 1994. Your Lordship. He had only 17 years of service. And he was also a regular absentee, Your Lordship.
Where's your
He was
representation?
conducted
Lordship will kindly see
Where is
page
it?
34.
Where's the representation?
Page 34.
There's an acknowledgement here.
Right on the top, my lord. It's a little
Acknowledged.
dark, but Lordship will kindly see on top, 2nd Battalion, so and so.
Accountant.
Received on 6/2. Yes. This is the counter, and the counter they received it, Lordship. If that is the case, my lord, the representation is there in the
Annexure
petition.
7. This is Annexure 7.
Yes, yes, Annexure 7.
What is this on top?
Yeah, that is the seal of the counter officer at the 2nd Police Battalion.
Where, we don't understand.
Lordship will kindly see signature 6/2.
Where's the receipt? Where do you get this from? This photocopy of
No.
this, what do you annex on top?
No, no, this is the copy which has been submitted to them, the Xerox copy of that.
No, acknowledgement is given on top of the letter.
Yes, yes, that's how they have given it, Lordship. At the time of Xerox, it got a little dark. That's the only.
Please.
No, the
You
representation
please
is.
obtain instructions.
No, now, my lord, the representation is there in the writ petition. If
They deny it.
No, the seal is there, my lord.
What seal is this? On what instructions are you saying this seal? It's some account officer's signature.
This is the person in the counter, Lordship.
It's addressed to whom?
It's
It says
addressed
the
to the
commandant. Where's the
commandant of
commandant's
sec-
signature?
Commandant's signature is not there, but it has received by the accountant of.
So MS Ailingwa, Learned Counsel for the LRGA,
So we'll-
one respondent has disputed the existence of the representation dated. What? What's the date?
Lordship, representation dated 6th February.
6 6/2/2024.
Where's the date given in the representation?
There's no date also.
No, because sometimes one of these people are not.
MS Alingwa learned GA for respondents has disputed existence of the representation said to be dated
6th February.
6 February 2022. A perusal of the annexure, which contains the affidavit, also does not disclose the date nor any concrete evidence that the representation was ever filed.
If I may,
you take instructions, otherwise you withdraw and file fresh.
If I may pray, my lord, this matter may be disposed of. I'll file the representation afresh, and
Yes.
they may dispose it of within a time frame.
As Mr. S. Deb fairly submits that as there is some doubt with regard to existence of the said representation, he prays that he will have to withdraw the petition to allow the petitioner to file a proper representation before the concerned authority. This next part is still objected to by the GA. Matter stands disposed of. Liberty is granted. Yes.
Obliged, Lordship.
Item number 12.
Lordship, we are going for respondents 1 and 2, Your Lordship. We don't have much role to play in this case because it's the Lady-King College, Your Lordship.
Lordship, in terms of the last order, Lordship, we have taken steps on the private respondents on 21/5/2024, Lordship.
She's entering a pen for Lady King.
On Lady-King.
The respondent's number?
3, 4, and 5, Your Lordship.
Oh yes, S. Shalam, the counsel entered appearance on behalf of the respondent 3, 4, and 5 as such. No further notice, as such notice is complete. Yes, you want time to file affidavit? He prays funds allowed. 2 weeks time to file affidavit. Next para. MST Yangi letter AG submits that the state respondents have no role to play.
Except we only pay the salary portion of the expenses of the college, and that has been released till February 24.
Have no role to play. Have limited role to play in the instant matter. She prays that, and as such, no action before coming to respondent at this stage.
And the salary expenses has been released up to 24.
I'm praying interim may be extended, Lordship.
And what's the interim order?
He was asked to quit and vacate the premises.
Interim order passes continue next day.
Your Lordship, and I just wanted this also, that only the salary portion of which we are responsible for has already been released up to 28th February 24, Your Lordship. Because there is a statement there that he has not been paid the subsistence allowance.
MST Yangi? Stop. She however submits that
subsistence allowance.
She submits that as the state is responsible for payment of the petition salary,
subsistence allowance
as admissible has already been paid since up to
February 24. Your Lordship.
Sorry, 2024. Yes. This after 2 weeks, interim order to continue next day.
My Lord, if I may, my Lord, it may have been transferred to the college account, my Lord, but we have not.
So that we'll see that in file affidavit.
Lordship. Hello.
Item number 13.
Please, Your Lordship, required to take step as per the last order. I believe the respondent, private respondent.
Yes.
Lordship, the prayer made here is.
One second. Let's see the office note.
I'm depending on behalf of the private respondent. I have just received instructions. And I'll file my power.
One second. Let's see the. Yes. Who is the private respondent? 4 and 5.
4 and 5.
You are paying for them.
For one only.
For?
I have not received
What about 5? You are paying for 5.
4 millions. 4.
No, he is for 4.
For 4.
Excuse me.
Respondent for 4.
No, who's paying for 5? Not paying for 5.
I have not received the copies of the petitions, so I have no idea.
Same Lamo Villa? Yes. What's the relation between Nangri Lang and Emerson?
No, Your Lordship, they are related to the same family.
They are not brothers.
They are related to the same family, Your Lordship. This writ petition is very limited. It's only to stay the release of the compensation pending disposal of a suit which is pending before the
suit pending, Mr. Molong.
My lord, the suit property is in East Casiles, whereas the land acquired is in Ribhoi district.
Stretch all the way to Ribhoi.
No
Start
connection, my lord. The parties are different.
You mean suit land,
East Casiles.
the suit, subject of the suit matter is in East Casiles?
Yes. Whereas the land acquired, where the payment of compensation is pending, is in Ribhoi district.
It's undisputed.
Undisputed. And parties as well have no connection between
Then
the
you file the
parties.
affidavit, then better.
My lord, may I make a small submission, my lord?
Yes.
Kindly see the prayer. This matter can be disposed with a limited observation. The prayer is at page 7.
Yes.
So it reads from para 6, in the premises and the circumstances stated above, it is therefore prayed that your lordships be pleased to issue rule calling upon the respondents to show cause as to why the direction should not be given to the respondent number 2 and 3 to the effect that pending disposal of title suit number so-and-so before the court of so-and-so, not to release the compensation against acquisition which is appeared at serial number so-and-so. That's all that they're praying for. Now, in view of section 76 of the Act,
yes,
a limited observation can be passed by your lordships. Kindly have section 76 of the Act of 2013, my lord.
Right, Act 2013. No, it's there. Okay, give the name of the act to her. Full name.
Right to fair compensation.
Right to fair compensation, 2013. Right to fair compensation. Yes. Section
76.
Who's the authority?
The special court ones.
You
So
can't
if
do
there is a
special court now.
dispute with regard to the ownership,
Let
at
them
that
file an
stage,
affidavit. If, like he says, it's totally a different.
I'll just clarify
piece
that,
of
Your
land,
Lordship.
yes.
Can you go to page 46 first, to the plain, Your Lordship. Here the suit premises, kindly 46, Your Lordship. Page 46.
Okay.
Para 2. Here the suit premises are 3 different properties known as Kanong Remba, Kanong Singir, and Ka Umsid. Now, Ka Umsid is the one which the DC Riboy is trying to get clarification. Can you see page 30? Come to page 30 also.
Yes.
They're referring to this land, Umsid village.
So, Mr. Molong.
My lord, they have mentioned here by name only. However, as the suit property, as per
This
the
stretch
claim,
starts from East
is
Casims,
in
goes
East
all the way to
Casims.
Ribhoi.
In
We
East
have given representation to DC Revenue to come and conduct an inspection as to whether that suit premises
At what
falls under
stage is
the
the suit?
Evidence stage,
evidence. We are not against
So
development
why
and
we come
construction.
that? Why do you apprehend that they're going to release a compensation?
We have
anytime
you
soon?
know appraised before the lower court to pass a necessary direction to DC, but the lower court had refused to do that. We said, and they don't
So
have.
why do you apprehend that the compensation is going to be disbursed?
Because
Well,
we were
apprehension
called
is based on what?
we have requested the DC ADC.
No, what is the apprehension is based on? The suit was filed when?
2005.
When was acquisition proceedings?
We have
completed?
received letter. The last letter received was
No,
on
when was acquisition started? When did it complete?
the acquisition has not started, Your Lordship, but we have received letter.
It's not
referring-
started.
it has started, my lord.
It has started, but the compensation is yet to be released.
Payment is on its way, and money have been paid as well. Only this parties are pending.
So we are apprehending that the compensation will release. We are not against development. Construction may proceed, but the compensation. We have requested ADC Revenue to come and
Let them
conduct
file
an
affidavit.
inspection.
Let them file affidavit. Yes, Mr. C.H. Molong entered appearance on behalf of respondent number 4
Let copies be
today.
supplied to me,
Lordship, there's a miscase, Lordship. Kindly, an
One
interim.
second, just in the main case. However, let's see the envelope. How come unserved? Service envelope. Go to. You are appearing on behalf of Nangrilang.
Nangrilang, my lord.
How do you get to know that the matter is pending?
Because they are within the clan members, there is discussion, and they have looked into the YouTube as well, and then they saw everything. They stopped
It's not YouTube meaning?
Like internet, my lord.
I mean, the court
Live-
proceedings.
Live hearing.
Because you unserved, your addressee has left. Return to sender. This is the one that was meant for you. You had collected from the court, and this. But you file a power first, and this is for number 5.
Number 5 had then has been that long gone, my lord.
That's for number
Decades
5.
ago. Yes, he had died decades ago.
You mean this 75 is the same Basan of
Yes.
Nongse? Then he's dead.
That long.
But officially in the
Decades
record,
ago.
we had to make him
He's
a
not
party.
dead.
Officially, he's not been substituted or been deleted from.
They are
No one had
liable
come
for
ahead.
abatement if they don't substitute, because they are a plaintiff.
While Masood Institute was alive.
Yes. The independency of the suit, we got an information that he had passed away, but no one had come ahead to legal heirs or anyone to officially.
The very fact that is a new, anyway. Yes. So
he remained in the suit.
Though officer indicates that notices to respondents 4 and 5 have returned unserved, appearance has been made today on behalf of respondent number 4, one Nangrilang, thank you, by Mr. C.H. Molong, who submits that the power will be filed in the course of the day. Stop. As such services taken to be complete with regard to respondent number 4. Stop. It is further submitted by Mr. Molong that respondent number 5 has
Died many years ago.
has expired many years ago, to which Mr. Marpan please be allowed to obtain instructions as to who will substitute the said respondent number 5. Stop. Mr. Counsel, learned counsel for 4 prayers be allowed. How much time for affidavit?
4 weeks time, my lord.
No, 4 weeks time. 2 weeks time for affidavit.
2 weeks time, my lord.
Yes. Yes. Just accordingly. Now, boy, Miss Case, what do you want?
Miss Case, just a direction not to release the compensation against serial number so and so, which as referred to the letter, page 30.
How released to a dead man?
No, this is addressed to the Rangbakur of Thank You clan.
Who's Rangbakur of this Psycho clan?
Not substituted, my lord.
There's no Rangbakur right now.
No.
There is Rangbakur.
Not parties in the suit.
That is disputing. They are
Not
trying to
parties in
dispute
the
that. They are trying to dispute. Page 30. That's the letter.
There's no impediment for me to take up this case for this court.
Not at all.
It's not,
We have
yes.
confirmed.
Not connected, yes.
It's page 30 also, this letter. This
No,
is
no.
referred as serial
Who is
number.
the, now to, who is going to take the payment?
No, this is,
If disbursed?
it is in
Different
the
parties, my
serial
lord.
number. In the notification, they have referred this letter. Can you come
this
page
clan
30?
land been an occupancy of many people.
Yes.
Then it'll be disbursed to whom? Who's the clan elder here?
Clan
You've
elder.
not said anything.
Yes, the representation, Lordship starts from page 31. Here the.
No, I'm looking at in this case.
Oh, miscase. Now the annexures. I just want to refer. In the miscase, I have not enclosed the annexures.
It's like stabbing in the dark, you know. Just wherever it might, wherever it might strike.
In the shadow, dark shadow.
So till the next date, it may be state the release.
What can
not
be
to-
stayed?
Because
You don't make
can
out
you come page 30?
you know, Pram Fasai,
This is addressed to Kur, thank you.
Where is that?
Page 30 also, of the writ. Thank you. Page 30. This is addressed to the President Secretary of the Kur, thank you.
Umsid village.
Yes. So, here the...
Who are these other 3, 4, and 5? They're not parties.
There are parties, but this is addressed to the thank you clan also.
How will you restrain? How will you pass orders when there have been parties?
The representation.
Neither is the
Representation has
so and so. Who is this Rosiman? Who is this Remulin?
These are other parties who may have connected to this.
Let me file affidavit first. At least after 2 weeks.
The miss case.
The miss case, we just have to get the main case for consideration like that. Unless you clarify and make it clear, Mr. Marpan.
The representation. I will show the representation.
Yes. After 2
So,
weeks.
Lordship, in that case, Lordship, the Rangwakun, I may add them as a
That you are at liberty because the parties have to be clear who are necessary, who are proper parties. Otherwise, how will we pass
the
orders?
person who was given this
Suppose we pass orders, you said they were never party here. Can they be bound by orders of this court?
Because they referred to this suit only, the Rangwakun, the representation. So I may be allowed to file an application.
You file a proper petition also. You get the correct people, not impede dead people.
No, but that fact, Lordship has not been, brought by the defendant to the lower court. So they were just a verbal submission that they have made. So no one had come ahead.
We'll have to 2 weeks, yes.
Yes.
Hearing from supplementary list, item number 5.
Yes.
Lordship, I was on the point
of collectors bound to adduce evidence.
Yes, Lordship. That his contention was this, that the special judicial officer has erred in awarding the uniform compensation. He ought to have awarded by following the belting system. My reply.
Sorry, so I didn't hear. What is belting system?
Belting system in the sense, Your Lordship.
Now, what are you submitting just now? Sorry, Mr. Jindal. What were you saying just now? I didn't hear you. I was other thing.
I'm coming
Start
back.
again.
So, Lordship, my learned friend's contention was this, that the learned trial court has grossly erred in awarding uniform compensation to all and a particular category of land. Trial court, his further submission is this, that trial court ought to have awarded the compensation on the basis of the belting system. Belting system in the sense, Your Lordship, that some villages are tacked together and the compensation is fixed for the particular belt, and because the road crosses number of villages, it's not only in one, it goes state. My reply to this is this, which I was dealing on the last occasions, that court has rightly awarded the uniform compensation.
You see it's rightly awarded?
Rightly awarded.
Okay.
For a particular category of land, because it cannot be different. And in that connection, Your Lordship, I just refer one judgment, then come to the another point. Your Lordship.
Now you see the court is right in giving uniform compensation.
Uniform compensation.
Okay.
And no fault can be found to that part of the judgment. Your Lordship will come to page 64 of my compilation. No, just a minute, Your Lordship. Page 60. Serial number 8 of the judgment, compilation of judgment. Paragraph 8 and 9. Lordship got it.
Yes. 25, section 25.
Yes, Lordship. Paragraph 8 and 9. As per provision of section 25 of the Act, the reference court cannot determine the value of acquired land at the rate lesser than the rate awarded by the land acquisition collector. In present case, the highest value determined by the land acquisition collector.
This is Himachal judgment.
That's Lordship.
1 second.
(2018) SEC online, Himachal Pradesh 2209.
Para 8 and 9.
Para 8 and 9. Lordship, I read once again.
Yes, please.
As per provision of section 25 of the Act, the reference court cannot determine the value of the acquired land at the rate lesser than the rate awarded by land acquisition collector. In present case, the highest value determined by the land acquisition collector is rupees 7,500 per biga. And in the light of the aforesaid provision of the Act, the value of the acquired land cannot be determined below rupees 7,500 per biga. In our case, Your Lordship, the land acquisition officers has awarded the maximum compensation for a particular category of land. Say, I have pointed out 220 per square meter.
Giri Masar land.
Yes.
That becomes the benchmark.
That becomes the benchmark, along with two, three more. And the judgment says it cannot be awarded, the reference court cannot award less than that amount which is determined by the collector himself. Paragraph 9. It is no longer res integra that when the land is acquired for a purpose of single use, Your Lordship, here land is acquired, single use is what? Construction of National Highway Road, which has no relevance with the nature and classification of the land on the basis of its agriculture potentiality. Its value is not to be determined on the basis of its nature and classification, but has to be determined on the basis of purpose for which it has to be put in utilization after acquisitions, considering the entire land as a single unit.
So you mean 220 should be the uniform rate A to Z?
A to Z. A to Z. As per this. and that the appeal is filed by the collector on this ground that the uniform rates ought not to have been awarded. Now, I come to the point of Your Lordship interest component, on which my learned friend is banking too much. First of all,
Yes.
One more judgment my learned friend wants me to place it at serial number 22,
Page
165. Yes, Lordship. 2005 12 SEC 564, where belting system was discarded and uniform rates were adopted. Your Lordship will just see paragraph 15 and 16.
Okay.
We have carefully considered the submission made on behalf of the respective parties, and we see no justification to interfere with the decision of the division bench of the Punjab and Haryana High Court, which in our view took a pragmatic approach in fixing the market value of the land forming the subject matter of the acquisition proceeding at a uniform rate. From the sketch plan of the area in question, it appears to us that while the land in questions are situated in 5 different villages, they can be consolidated into one single unit with little to choose between one stretch of land and another. The entire area is in a stage of development and the different villages are capable of being developed in the same manner as the land comprised in so-and-so, where the market value of the acquired land was fixed at a uniform rate of rupees 40,000 per acre. The division bench of the Punjab and Haryana High Court discarded the belting method of valuation, having regard to the local circumstances and feature, and no cogent ground has been made out to interfere with the same. In overview, in the absence of any contemporaneous document, the market value of the acquired land of village so-and-so, which were acquired at the same time as the land in the other 5 villages, was correctly taken to be comparative unit for determination of the market value of the lands comprising the land forming the subject matter of acquisition proceeding under consideration. No interference is therefore called for in these appeals, and they are all dismissed without order as to cost, Your Lordship. So here, when the land is used for a single purpose, the division bench of the Punjab and Haryana High Court discarded the belting system.
You have noted.
Yes. Then, Your Lordship, I come to the interest portions.
Yes.
Your Lordship, before I take Your Lordship to the substantive provision of the Act, I would like to point out, Lordship, that there are two broad categories of interest which are contemplated under the Land Acquisition Act. First is interest on the market value of the land. Second one is interest on the compensation.
Yes. 1940 Act.
Both are different. Both are different.
Yes.
And court is required to award interest at the rate mentioned in the Act itself. Both under the both head, that is interest on the market value, then interest on the compensations. So, meaning thereby, market value and compensation, these are two different things,
okay. Yes.
two different components. Now, interest on the market value is provided under 23(1)(a). Your Lordship will.
Just 20 years, got it.
One A.
Yes.
In addition to the market value of the land as above provided, the court shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on and from the date of the publication of notification under Section 4, under Section 4, subsection 1, in respect of such land to the date of the award of the collector or the date of taking possession of the land, whichever is earlier. Then come to 23.2. In addition to the market value of the land as above provided, the court shall in every case award a sum of 30% on such market value in consideration of the compulsory nature of the acquisitions. Your Lordship, here 23.1a talks about the interest on the market value for a particular period, and here the rate of interest is specified in the Act itself, 12%. Then 23.2 talks about the solatium. Here solatium is also qualified that it will be awarded on the market value. Now come to your Lordship section, so far the second category of interest is concerned, it is provided under Section 28A. 28. Your Lordship will find here, the collector may be directed to pay interest on excess compensation. Here, Your Lordship, the legislature are not using the market value. They are using the interest on compensation, which is a wider term.
Yes.
If the sum which in the opinion of the court, the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensations, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9% per annum from the date on which he took possession of the land.
The difference between the awarded amount by the collector and by the court.
Yes, Lordship.
On the difference you have to pay.
Yes, Lordship.
9%.
Yes, Lordship. But this is on compensation.
Yes.
No, what is the difference between market value and the compensation?
What is the difference? Suppose like now they paid 20 rupees, now you're being paid 160 rupees by reference court for 140 rupees.
Yes,
from
Lordship.
2003
No,
till
Lordship,
the time
compensation will include so many things. Even solatium is also will be included.
How?
No, I'll show you, Lordship. Solatium also is a compensation, and for the purpose of awarding interest under Section 28A, it is one of the component which will be taken into consideration. Because this is a compensation. Rate of interest is also different here. It is 9%. So far the compensation is concerned, it is 9%. And so far the market value is concerned, it is 12%. Your Lordship will just see, as compensation, the award of the court may direct that the collector shall pay interest on such excess at the rate of 9%.
Now this is discretion power of the court looking the facts, circumstances of a very particular case.
Yes.
May. Suppose they feel, yes, they've been wrongly deprived of
No,
the enjoyment.
yes, Lordship.
Yes.
No, my purpose of pointing out this thing is this: we have to see the interest awarded by the court whether it was on compensation
Or
or
on-
it was on the market value.
Okay.
Provided that the award of the court may also direct that where such excess or any part thereof is paid into the court after the date of expiry of a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of such period of 1 year, such excess part thereof. This is the similar provision which we found in section 23 1A. 1A and 1A, section 23 1A. Now, come to your lordship, section 34.
Yes.
Payment of interest. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9%. Here also the phraseology is used, compensation per annum from the date of so taking possession until it shall have been so paid or deposited, provided that if such compensation or any part of thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date of expiry of the said period of 1 year on the amount of compensation, the part thereof, which has not been paid here. Now, this is also in the same way that 15% if not paid within the stipulated period, and for the stipulated period, it is 9% per annum. Here, Lordship, I will point out judgments. First judgment, Your Lordship, I would like to point out page 30.
Same one.
Just a minute, 1 minute. 1991.
4 SEC.
4 SEC.
195.
195. I'm different para I'm referring to. Para 23 and 24. Page 30.
1 second. Para
23, 23 and 24. Just allow me to read just before 23 para. A reading thereof does postulate that if in the opinion of the court, the land acquisition officer ought to have awarded compensation in excess as found by the court, then the court may direct that the government shall pay interest at the rate of 6% per annum on the excess amount so found as compensations. The payment should, on compensations, the payment should be from the date the land was taken possession by the division Peskar till the date of the payment of the excess amount in the court. The question therefore is whether interest is an integral part of the word compensation under subsection so and so. In Ram Meher case, the question that came up for consideration was whether the word interest on market value in section 4.3 of the Land Acquisition Amendment Act 1967 would include payment of interest on solatiums. Additional 15% solatium under subsection 2 of section 23 certainly forms part of compensation. I repeat once again, additional 15% solatium under subsection 2 and 2 of section 23 certainly forms part of compensation, as under section 23 the market value of the land would include solatiums. But market value and compensations are distinct expressions and have been used as such in the Land Acquisition Act. The key to the meaning of the word compensation is to be found in section 23(1), and that consists of market value and solatium on the market value, which is stated to be considered for the compulsory nature of acquisitions. Therefore, this court held that the term market value has acquired a definite connotations in judicial decision if the word market value and compensation were intended by the legislature to have the same meaning. It is difficult to comprehend why the word compensation in section 28A and 34 and not market value was used. So market value cannot be equated to compensation. The market value is therefore only one of the components in the determination of the amount of compensations. If the legislature has used the word market value in section 4.3 of the amending act, it must be held that it was done deliberately, and what was intended was the interest should be payable on the market value of the land and not on the amount of compensations. Otherwise, there is no reason why the Parliament should not have employed the word compensation in the aforesaid provision of the amendment. Then para 24 is not so much required here. On para 23, your Lordship will find a distinctions between these two.
Market rate, market value and compensation.
Yes, Lordship.
Yes.
Then your Lordship, my learned friend has referred one judgment, 43220. 432. Page 2011 4. No, not by the collector, which he has relied. वो इसका folder का है, उसकी judgment है. Yes. Lordship, my learned friend has given one judgment. It must be with Lordship. 2011 4 SCC 363. 2011 4 SCC 363.
2004 734 363.
There are two judgments.
Yes, okay.
One which I am referring to 2011.
This was given by you, Mrs. Sen.
Yes. 734 was mine.
No, 363 is also yours. There are two judgments.
Yes.
Both.
Yes.
No, sir, your lordship will give me 1 minute time. Yes, your lordship, I'm extremely sorry. 2011 4 SCC 734. 734. I'm reading from paragraph 9. My learned friend has relied on 10, 11, 12. I am just referring to paragraph 9. May I read, Lordship?
Yes, yes.
Paragraph 9. In Sundar versus Union of India, a constitution bench of this court held that the term sum awarded or amount awarded occurring in section 34 and 28 of the Act would include not only the compensation determined by taking note of the 6th factor mentioned in section 23(1) of the Act, but also amounts awarded under the remaining subsection of section 23 as well, for the purpose of calculating the interest. The words compensation to be awarded used in section 23(1) of the Act refer to the total of the sums awarded with reference to the 6 factors enumerated in section 23(1). On the other hand, the words amount awarded or sum awarded in section 28 and 34 of the Act refers to the aggregate of the compensation determined by the court under section 23(1). The additional amount payable under section 23(1)(a) and the solatium payable under section 23(2)(a). For calculating the interest under section 28(a) and 34, solatium also will be included. It is a part of the compensation, 30%. So one more judgment your lordship may like to consider, which is not in my compilation, 2012 5 SCC 432. मेरा कौन सा था? Yes, Your Lordship. Paragraph 25 and 26 wrongly written here.
Yes, which paras?
Para 25 and 26. Para 25 and 26. This case also, Your Lordship, refers to the Constitution Bench judgment which was quoted in paragraph 9 of 2011. I should have bought that Constitution Bench judgment in any case.
Get it now?
Huh?
You asked me to get it now. Is there?
Yes, Lordship. That
Sundar, whatever was that?
Sundar versus Union of India,
Yes.
2001, 7 SCC 211.
2001, volume 7, SSC page.
Page 211.
Yes, because yes.
They are
But
following.
This
they,
is where they've. It's come from there only.
It came from there.
Place is Sundar only.
Yes, my mistake, Your Lordship. This aspect, maybe this volume was not available with me, right? But anyway, this I'm reading paragraph 25, Your Lordship.
Yes.
This aspect has been considered and answered by the Constitution Bench of the India, Constitution Bench in Sundar versus Union of India, while considering various decisions of the High Court and approving the decision of the Punjab and Haryana High Court, rendered in that type of land in the sale deed was not mentioned, that what classification of the land it is.
Yes.
Third ground, area in the sale deeds.
Not mentioned.
Area in the sale deed extend only to a small area.
Area very small.
Small area.
I mean in square feet.
Yes, Your Lordship. No, I'll just take to Your Lordship those sale deed. Just give me 2 minutes. The last ground of rejecting this, that these were not executed at the relevant time when notification under section 4 was.
That is relevant.
That is relevant, but that is relevant to Your Lordship. But I will show, but in absence of any other things, court can draw inference that if the market value of the land in a particular year was so much, after 7 years or 5 years, it may, at least it cannot go less than that. And these are the 4 grounds on the basis of which the trial court have not accepted these 4 sale deeds. So, I may take to Your Lordship the finding of the tribunal at page 136 on this issue of the volume 1. (136).
Today also you won't be able to complete, that means.
Pardon, sir?
Today also you won't be able to complete.
I will try, sir. Tomorrow, whether Your Lordship will be.
Tomorrow will be difficult.
Let me see how far I can go.
Another half an hour, yes. Because other matters are there also, yes.
At least, yes, this is a
major
major thing.
136 findings.
Major thing for me.
Very interesting also, but the thing is, but we have to go through all this because it's, how can we arrive at any conclusion then? Yes.
Yes, this is page 136 of paper book 1. How the reference court has dealt with these sale deeds. These findings are common almost in all the cases. From the evidence of claimant number 1, Lordship, may I?
Yes. That means exhibits 4, 5, and 6.
Exhibit 4, 5, and 6.
Yes.
From the evidence of claimant number 1, it is seen that the sale deeds as commonly relied by all the claimant at Exhibit 4, Exhibit 5, and Exhibit 6, which are all undisputedly not registered, unstamped. This is one of the grounds which I have already told. But the documents are also not executed at the relevant time of acquisition herein, but the same was relied for the rate of acquired land herein as projected rates on assumption of rise of rate since 1993-94 as per the sale deeds to 2003, expectedly to rise especially with the hike in price due to coming of four-laning highway. But on perusal of the said Exhibit 4, 5, and 6, it is seen not only the rate is at variable from one another and not specific rate, but the lands therein are also not specifying on the type and classification of the lands. That is another ground. So that to enable this court to compare the value of the land of the claimant herein, the acquired land herein being referred commonly for all 68 referred claimant for a large extent of acquired land of 2,80,000 meter, and the claimant number 1 admitted the extent of his land to be 2106 square meter, while the sale deed brought for supporting their claim of the enhancement of rate is but of small extent of land. The trial court has relied on this judgment. As per Honorable Supreme Court ruling recorded in AIR 1995 SC 840, para 7 and 14 and 22, the claimant is required to discharge the initial burden of proving that the amount of compensation determined in the award under Section 11 was inadequate. But when the claimant will succeed in proving that the amount determined under the award of collector was inadequate, the burden of proving the correctness of award shifts on the collector, who has to adduce sufficient evidence in that behalf to sustain such award. Court cannot determine the value of land unless it gets over the finality and conclusive evidentiary value attributed to it under Section 12 by recording a finding on consideration of relevant material therein and the amount of compensation determined under the award. Assuming that Exhibit 4, 5, and 6 are the sale deed duly registered, but the area as per the sale deed as Exhibit 4, 5, 6 extends only to their area therein as 5453, 4550, 5250 square feet, respectively. For that also the court is not always bound to determine the market price of the large extent of the acquired land on the basis of the prices fetched by the alleged sale deed of Exhibit 4, 5, and 6. For this view, it was held the above, citing ruling therein at para 14. Para 14 is quoted. Besides, on perusal of Exhibit 4, 5, and 6, it is not clear what kind of nature of land it is, since is not reflected thereon, whether it is paddy field or arable land or homestead or quarry land, for satisfactory comparison to the acquired lands of the claimant herein in this case. Decision. Hence this court on issue of rate found the claimant not able to prove satisfactorily that the amount determined under the award of the collector was inadequate, since their reliance of Exhibit 4, 5, and 6 are found not satisfactorily comparable to the land of claimant herein, as the type of the land in the said sale deed at Exhibit 4, 5 and 6 are not specified as to what type of land they are. However, since the land of the claimant number 1 is apparently arable land with the plantation thriving thereon, and since it is also seen from assessment of collector to some arable lands of other, the assess rate was 100 per square meter, and to some other by rupees 80 per square meter, and yet to some other by 60 per square meter. Hence, this court awarded an enhanced rate of acquired land of this claimant number 1 to the rate of maximum rate as given to others in the same acquisition at rupees 4. So, on these 4 grounds, Your Lordship, which I have stated, which the on the basis of which the trial court has rejected these 4 sale deeds. My submission is this, Your Lordship, that here the court went wrong. Now, court has not considered in it the sale deed along with its evidence. Now, I have already referred that we have examined 3 witnesses who have proved the sale deed Exhibit 4, 5 and 6. Your Lordship will take additional paper book. At page 1,
this is the statement affidavit.
Statement on affidavit. I, Mr. So-and-so, aged 75, occupation farmer, resident of village Undobrit, Umrai, Ribhai district, do hereby solemnly affirm and declare as follows. That I was the headman of village Umdro-Tit, Umrai, Ribhai district from 1990 to 2005. And in that capacity, I used to witness the sale deed executed in my village. I am shown the sale deed dated 5th March 1993, executed between so-and-so in respect of land measuring 5453 square feet situated at the village Umdo Trit. Your Lordship will just mark it here that this is the village from which the land was acquired. It's not that adjacent land. It is the same land which was the subject of acquisitions.
Yes.
Which was sold for rupees 8 lakhs only. The buyer and seller of the said land appeared before me, and they have signed in my presence, and I recognized their signatures, and I have also put my signature with seal as of having witnessed the said sale deed in our area as per customary practice prevailing. There is no system of registration of sale deed. The aforesaid sale deed is already exhibited as Common Exhibit 4. Exhibit 4/1 is my signature. Exhibit 4.2 and 4.3 are the signature of seller and buyer. That the statement made in this affidavit are true to my knowledge. Now, Your Lordship will see the cross on this witness, which is very important witness, and what is the nature of the cross?
Is PW 69?
69. crossed by Advocate Jaha. I do not know the exact market rate of the land in my area, though the land on the roadside is more costly than the land in the interior of the village. It's a fact that Exhibit 4 is not a registered sale deed. Your Lordship will find that the collector in his cross-examination, while crossing my witness, has not challenged the genuineness of
Or a
this
sale deed.
sale deed. Sale deed. And he has raised no objection with regards to the exhibition, with regard to making the sale deed as the exhibits, that this cannot be exhibited.
No, he never take objection.
No, he never took any objection. He never took any objection, which is important for the purpose of determining this case, Your Lordship. The collector has accepted the sale deed, in other words. The only objection is this, that it is not a registered sale deed. That's all. More than this, there is nothing. Now, similarly, Your Lordship will find page 4, witness number 70. He says that I was the headman of village Pelim Umrai, Rivai district from 1989 to 2000, and in that capacity I used to witness the sale deed executed in my village. I am shown the sale deed dated so and so, executed between you so and so in respect of land measuring 4550 square feet, situated in the village Pylon. Your Lordship again will mark, this is the village where the land was acquired. It's not the adjacent land. And he further says, which was sold at rupees 7,500.
What's the area of the land?
Pardon, sir? Area of the land is 4550 square feet.
Only 450 sold for 7.5 lakhs in the year 1994.
Yes.
Even by a rule of thumb also, highly unbelievable.
Maybe, Your Lordship, but we have to go by evidence, and the challenge made by the collector in this case, Your Lordship.
Yes, 94.
I have also put my signature with seal as of having witnessed the sale deed. The secretary of the village, Shri U.B. Walang, has also witnessed the sale deed and put his signature. The aforesaid sale deed is already exhibited as common exhibit so and so, and signatures are also exhibited. Then Your Lordship will see here cross-examination. I.C. Jaha. I do not know the exact prevailing market rate of the land situated at Pylon area where I am the admin at that time. It is a fact that Exhibit 5 is not a. The challenge is only that it is not a registered.
On the ground that it would have been totally admissible if it is registered. That's the only thing. Yes.
No, I'm trying to show you, Lordship,
of course.
The manner into which the collector is conducting these cases, this type of cases. They, in the Garoville also, they don't file any written statement.
In a very,
casual manner,
attitude,
and that has to be checked, Your Lordship. Otherwise, Your Lordship, this is a public money, and they will not do their duty, and they will again leave the matter to the court.
Yes.
What they were doing for 20 years, the case was pending.
Yes.
Similarly, Your Lordship, with regard to Exhibit 6, we have examined CW 71. He is also from the village where the acquisition of the land was done, not the adjacent land. He exhibits sale deeds exhibit 6. I am just taking to your lordship to the cross-examination at page 9. The prevailing market rate of the land in my area during the year 2001-2002 is rupees 150 square feet. At least this witness says that at the
Sale deeds is how, what's the area of land? 5250?
5250. 5250. I have no documentary proof to show that the market rate was so and so. It is a fact that Exhibit 6 is not a registered document. Now, these are the 3 witnesses which we have examined. Who have exhibited the sale deed marked as Exhibit 4, 5 and 6, and there is no challenge worth of anything.
Only does the registered.
It's not registered, that's all.
Yes.
Had they raised the objection then and there, I would have made or reduced other evidence in order to prove. They have not raised any such things. Then, your lordship, I take to your lordship the sale deeds. Sale deeds are at which page?
Where's the exhibits?
Page 68.
How does it still paper book?
Same paper book.
Was the stamp paper, was it examined behind date of sale and who sold the stamp paper and whether...
That's the thing, your lordship, that they have not done anything.
It's absurd, really.
They have not done anything.
It's just like this on a stamp paper of 2 rupees.
2 rupees. Now, English translation copy is available here, your lordship.
Even then, yes.
It may be a piece of paper, your lordship, but according to law, it has been made exhibits.
And according to you, it's not been rebutted substantially to warrant its non-consideration in the fixation of the market value.
Yes.
Yes.
Your lordship, here the area is
5453.
5453. Price is 8 lakhs.
Why was it? See, even the very fact that area is anyway. Carry on. Yes.
It's written on top.
Yes.
Now, according
what
to
called,
no,
because ones are called like what they write in the tea shop, no? Small tea shops they have.
No, this is the system, your lordship. Though Registration Act is made applicable in the state of Meghalaya, but your lordship will find.
So even then, even if it's not registered, also sometimes in other places, even the officer's EM is registered. So sales conducted, is signed, is stamped. And then
this is also stamped by the headman.
This is a stamp is entered the register. That's the thing.
They would have called the register. No.
There's a story also. There was one headman. He already was headman maybe for 10 years ago. He still carried the seals in his pocket. So anybody needs any seal, he'll sign those dates 10 years ago. Anything, just give him, half a bottle of whiskey. That's it.
This also happened that death certificate. What date he died, we don't
exactly.
know.
Those dates that was given in the other cases. In this case,
the person
only,
is roaming.
In this case only,
roaming. Death certificate is signed.
No, in this case only, death certificate produced for which year and issued and a discrepancy of 7 years from the time he died and the time the certificate issued. The headman said he died in 2006, and your death certificate said he died in 2015.
So many wonders are there.
Oh, really?
And that's why, Your Lordship, the council
Very difficult.
have to discharge their duty.
To the best of their ability.
To best
and
of
the
their
court
ability.
also to try
In
and
this matter, Your Lordship, in this matter, Additional Advocate General W.H.D. Sinkan was leading. Who's well conversant with the land system? Who was well conversant with the land system?
We're not well conversant with law, so
No, only Your Lordship will, on this sale deed, according to the area and the rate, because square feet rate is not mentioned, I have calculated, Your Lordship can just make a note on the sale deed.
Now, what's the real amount? See, overrode over 8 lakhs. First said, okay, let's put 2 lakhs. They said, no, make it 8. You can make out here. You know? See the overwriting here. There's a 2 before.
No, Your Lordship, according
How
to
can the court, take this to be, a document which will, like really indicate the market rate?
No, Lordship, Lordship is fully right. And
have to
the
discard it.
problem is this, Your Lordship, that evidence has come.
No,
Evidence
but
has come.
So
Only
we can
Your
first
Lordship.
appeal, then we can ask for reappreciation.
Pardon?
For reappreciation of the evidence. On limited points.
Yes.
This one also, the land area was written something else, written 757250, then changed to 5250. Maybe handwriting is better here. Otherwise, yes.
Yeah, Lordship, in Exhibit 4, according to the valuation done, the rate is coming because 146.70 per square feet. I have calculated because Your Lordship, the 146.70.
146 rupees.
146.70 per square feet, and per square meter it is coming 1528.12, because collector has assessed according to the square meter. The square meter rate in this sale deed is coming 1528.12 square meter. My friend may recalculate it. I have done it. No, in other sale deed, Exhibit 5 at page 71, it is also from the same village of acquisitions. The square feet rate is 163.83 per square feet, and per square meter rate is 1774.22 square meter. Then on Exhibit 6, the rate is 123.80 square feet. Lordship, in this, I think I have not calculated square meter. I'll ask my friend to do it. This is square feet.
Yes.
So,
you touch upon interest, touch upon reply to belting method, collector bound to adduce evidence. Yes. And then,
continue, Your Lordship, next date.
yes. for here next week. Let's go for the hearing. Next, we'll have it
Monday. Monday.
Monday's which date? Oh, yes, part heard to resume on 10th.
All these three headmen were above 70, 75. If we locate them, we cannot get.
My lord, their memory.
Remarkable.
Remarkable memory.
Yeah, but then you can't have many old people have very exceptional memory also.
Here, Your Lordship, this is a case where Lordship will give a observation that the manner into which they are doing here. In so much trouble I have taken as a counsel of the claimant.
We can understand. In fact, because in all these cases, Mr. Jindal, the counsel has to make up the case.
Yes.
That's the thing.
I have become old in this case.
Keva. नहीं ये नहीं अरे सुनो ना क्या Yes. Next matter.
From the main list, item number 14.
Yes.
Well, this is that matter of the youngest daughter now, yes. but they are cousin now. So Your Lordship may pass necessary orders.
Yes. No, we'll have to hear it. Because the only thing is that only one issue that was decided whether liability evicted on issue number 17. That's the only thing I want to hear you a little bit on that, and whether any rights devolve upon, we can understand if they're only sisters, but and then we'll have it another day, and then devolve. Sorry to make you wait, or devolve on. After 1 week, we'll finish it off. Because today the other hearing is there, that's why.
Yes, sir.
Yes.
Okay, sir.
Ms. Yuban, you got another matter?
My lord, item number 15 is my matter. That is those two wives fighting for a pension, my lord.
Where's the petitioner?
My lord, I think this petition deserves to be dismissed, my lord.
Yes.
Because we have given them enough chance when they could not even make out the legal
No.
rights.
After you said that he has to share the debts, also he run away.
Yes, they run away. So therefore now, my lord.
It's okay. Let him be, poor fellow. Because after you said that he has 9 lakhs.
Yes,
the debts
yes.
that the deceased has to pay.
Yes, so far there was no liability. They keep on asking.
Yes, he's pressing. None appears for the petitioner. In the interest of justice, the matter.
1 week, my lord.
Yes, still after 1 week. Yes.
Obliged.
Okay. Yang hap cek lang day. He did.